The American justice system is not perfect or flawless. Few would claim otherwise, especially these days. But one hallmark of our justice system is this idea that people get their day in court. We may disagree on the outcome, but unlike dictatorships, our government system requires both sides are heard, pressed on their claims, publicly and transparently. That's why so many crime shows build on those dramatic courtroom scenes. It's why even controversial outcomes like O.J. Simpson's acquittal for murder arrive in a public process where everyone can see the evidence and the verdict. It was a memorable one for O.J.
We, the jury, in the above entitled action, find the defendant Orenthal James Simpson not guilty of the crime of murder, one or more crimes of murder of the first or second degree to be not true.
Do you waive reading of the verdict as recorded?
Yes, we do.
Ms. Clark. Thank you.
That O.J. verdict is infamous for many to this day. And O.J. did not just get that day in court. While many recall the not guilty verdict in that criminal murder trial, what some may not remember is under our system, O.J. faced another day in court where he was found guilty for the same incident and allegations.
It was 12-0. It was a unanimous verdict all the way around.
O.J. Simpson's lawyers arrived at court in a foul mood, having lost their case.
We assess punitive damages against defendant Orenthal James Simpson in favor of the plaintiff, Frederick Coleman, as follows: $12.5 million.
In this civil trial, the plaintiffs only had to prove Simpson was probably the killer, not that he was guilty beyond a reasonable doubt.
Our family is grateful for a verdict of responsibility, which is all we ever wanted.
How was O.J. found guilty of those killings in one valid American courtroom and not guilty in the other? The reason's important. It brings us to our special report right now. The U.S. system intentionally provides two avenues for accountability. Door number one's the most severe, a criminal trial that sends guilty people to jail. Door number two is that civil trial, which punishes guilty people through fines and civil penalties that do not involve jail. Only the government can send you through door number one, or you can lose your liberty. Any person can try to send you through door number two. And like other checks on power, this feature of our government system was designed so that courts could be used for accountability by both the government, through prosecutors, and by regular citizens. And that actually works in many areas. If a doctor attacks patients while they're unconscious, the government can prosecute the doctor, and those patients can sue the doctor. But you know where the evidence shows this doesn't work? It's one of the areas of American life where our vaunted system often blocks people's day in court through both door number one and door number two. I'm talking about American policing. Because door number one's usually closed completely. The prosecutors who work with police to build all their cases and do their jobs, they don't like to typically turn around and indict their close police friends and colleagues. In cases of illegal searches and battery, and even in the severe case of killings, door number one is usually closed. We have data on this over 15 years with thousands of police killings in America. You can see there was not a single murder conviction of an officer on the left side there of all those years. And then in those final few more recent years, you have one or two a year among thousands of killings. So we know that door number one is mostly closed. That's why one of the main calls for change by protesters for police reform recently has been to deal with this. It's why the criminal conviction of former Officer Chauvin for murdering George Floyd was so rare. You just saw 0 or 1 a year. Now, what about door number two? Even if officers almost never face that accountability in criminal court, which is a separate issue, can't regular citizens sue them in civil court to at least seek some accountability and some deterrence for misconduct? Well, it turns out that door is only slightly cracked because unlike doctors or barbers or corporations, police are automatically immune from many of these suits. The reason is not that voters chose to give them immunity or even that legislators passed a law in Congress. It's a made-up protection, which we'll get to. But first, let me show you how it works in practice, because this is so important. Police kill a person. Take 23-year-old Luke Stewart, who was unarmed in his car with a cigarette. When police escalated a stop, he tried to drive off, He was killed. Officers tried giving him CPR after killing him, but he was dead on the scene. Now, prosecutors closed door number 1 with no charges. So Stuart's mother turned to door number 2, suing police over that killing. And a judge found the police department used a tasteless and, quote, irresponsible approach to policing, but granted the officers immunity from the suit. Ms. Stewart never got her day in court for her son's death. Now, that's the norm. Most instances of alleged police brutality never lead to a case in the first place. But for those that do, most never get to trial because judges dismiss them by just giving the police immunity. No trial needed. There's a recent Reuters count that found judges grant police immunity the majority of the time this even comes up. 57% of the cases tossed before trial. That translates to tens of thousands of cases stopped in their tracks. And in some of the southern states, which actually have worse police brutality allegations, federal judges were tossing cases in favor of police immunity at this higher rate. You see there, 64%. Hey, I'm Ari Melber from MSNBC. You can see more of our videos right here, or better yet, subscribe to our YouTube channel below. You could have been anywhere in the world, but you're here with us, and we appreciate that.